Breach of contract. In this podcast, I will talk through the principle of breach of contract, identifying what is a breach, and then I will move to look at the consequences, the effect of breach, and talk briefly about remedies. Professor Treitel has described a breach of contract as occurring when a party without lawful excuse fails or refuses to perform what is due from him under the contract, or performs defectively or incapacitates himself from performing. Only by analysing the specific terms of a contract against the situation in question can you determine if there has been a breach. The starting point in analysing any contractual dispute must be to understand the terms of the contract and the context of the alleged breach. Generally speaking, there is no requirement to establish that the breach was intentional or to prove that a party was at fault. It is sufficient that the party simply failed to perform what was required of it under the contract or to have announced an intention to do so. Similarly, it is of no use for a party to claim that, although they did not meet their contractual obligations, they acted in good faith. Perhaps obviously, the burden of proof lies with the party claiming the breach to prove that there was indeed one. Although I've said that the general principle is that there's no requirement to establish that the breach is intentional, where a term requires only that a party shall take reasonable care in its performance, although the breach is still strict in the sense that the party has or has not breached the term, the claiming party would need to prove that the level of care deployed by the other party was less than that which would be reasonable in the circumstances. We turn to effect of breach, and it is perhaps tempting to jump straight to the position that breach of contract automatically leads to termination. This would not be correct. While a breach of contract may lead to termination, not all breaches permit a party to terminate, nor does a breach require a party to terminate. Termination is a right potentially available to a party, rather than an inevitable consequence. Second, a breach by one party does not entitle the other party not to perform their obligations under the agreement, unless they are prevented from doing so by the other party's breach. Every breach of contract gives the innocent party the right to claim damages, unless the contract itself limits or excludes that right. It does not matter whether the term in question is a warranty, a condition, or an innominate term. I will talk about the calculation of damages in a separate podcast. Not all breaches give the innocent party the right to terminate. A breach of warranty, for example, is irremediable only in damages. A breach of condition, however, gives a party an additional right to terminate, as does a breach of an innominate term if the situation is sufficiently serious. Where the fundamental breach happens before a party's duty to perform under the contract expires, the breach can be described as anticipatory. This might, for example, be the situation in which a party is clear beyond reasonable doubt that they are renouncing their obligations under the contract. Although it must be clear, it need not be something that's evidenced in writing, and an anticipatory breach by conduct is possible, such as the situation in which a party prevents himself from performing. Consider the situation in which I contract with you to sell you the chair on which I am sitting and deliver it to you next week. If, tomorrow, you learn that I have just sold this very chair to someone else and give it to them, I have prevented myself from completing my bargain with you. In such a situation of anticipatory breach, the innocent party has two options. They can either accept the repudiatory breach and take action immediately, or else affirm the contract and refuse to accept the breach. Where a party elects to accept the breach and communicates acceptance to the other party, the contract is treated as terminated from that point onwards. It removes any continuing or prospective obligations on either party and enables the innocent party to claim damages from that point. Accepting the breach may be desirable where a party needs to demonstrate that it has mitigated its loss, and, for example, needs to sell something which was otherwise bound to sell to the breaching party to another party. A party's failure to continue to perform its obligations under the contract is likely to be taken as acceptance of the other party's repudiatory breach, as otherwise that party is too, in itself, in breach. Where a party affirms the contract, insists on its performance, the contract remains in existence and both parties have a duty to carry on performing their obligations under it, including the innocent party, which must continue to perform. An innocent party's continued performance of the contract is likely to be treated as affirmation, as is failure to accept the breach or communicate acceptance of the breach in a timely manner. See Formula One team and Etihad Airways.